In 1993, one attorney took two confessed killers, men who had walked into their parents' living room with shotguns, and nearly walked them free. Not with an alibi. Not by proving they didn't do it. With a legal doctrine most people have never heard of. A doctrine that turns on a single word: belief. On August 20th, 1989, at 722 North Elm Drive in Beverly Hills, Jose and Kitty Menendez were watching television in the den of their 9,000-square-foot mansion. Jose Menendez was 55 years old, a Cuban immigrant who had arrived in the United States at 16 with nothing. By 1989, he was CEO of Live Entertainment, a former executive at RCA Records. His personal estate was valued at $14 million. His wife, Mary Louise, Kitty, sat beside him. A former beauty queen. A woman who, by most accounts, struggled quietly with depression and a marriage that demanded silence. Their sons, Lyle and Eric, 21 and 18, were supposed to be out that evening. They weren't. At approximately 10 p.m., both brothers entered the den, armed with 12-gauge Mossberg shotguns. They had purchased the weapons 2 days earlier at a Big Five sporting goods in San Diego, over 100 miles from home. They opened fire. Jose was shot 6 times. Once at point blank, range in the back of the head. Kitty, who tried to crawl away, was shot 9 times. The final blast hit her directly in the face. 14 shotgun rounds, 2 parents, 1 room. After the shooting, Lyle and Eric drove to Mulholland Drive and disposed of the weapons. They went to a movie theater and purchased tickets, an alibi. When they returned home, Lyle called 911, his voice breaking.
Beverly Hills emergency.
Yes, police.
What's the problem?
Seven,
What's the problem? What's the problem?
someone killed my parents.
Pardon me?
Someone killed my parents.
What? Who? Are they still there?
Yes.
The people...
No.
Were they shot?
Hey, man,
Were they shot?
Yes.
They were shot?
Yes.
For 6 months, no one suspected them. During those 6 months, the brothers spent roughly $1 million of their parents' money. Rolex watches, a Porsche, a Jeep Wrangler, real estate. The day before their parents' funeral, Lyle dropped $15,000 on 3 Rolex watches. In the limousine leaving the service, he showed off his new leather loafers and said to his father's secretary, "Who said I couldn't fill my father's shoes?" Whether the Menendez brothers killed their parents was never the question. They did. They've always admitted it. The question is how one attorney, arguably the best criminal defense lawyer in Los Angeles, nearly convinced the world they had no choice. Her name was Leslie Abramson, and she had done this before. To understand what happened in that courtroom, you need to know who Leslie Abramson was before the Menendez case. Born in 1943 in Queens, New York, Jewish immigrant family, law degree from UCLA, class of 1969, California bar, 1970. She spent 6 years as a public defender. Then she went private, and she became something rare, a woman who dominated the most violent, most hopeless cases in the Los Angeles criminal justice system. By 1990, Abramson had defended over 600 felony cases. The Los Angeles Criminal Courts Bar Association named her Trial Lawyer of the Year, twice. She was the first woman to serve as president of the California Attorneys for Criminal Justice. Dominic Dunn from Vanity Fair called her, and I quote, the most brilliant Los Angeles defense lawyer for death row cases. Now, here's the detail that changes everything. In 1988, 1 year before the Menendez murders, Abramson defended a 17-year-old named Arnel Salvatierra. Salvatierra had shot his father 3 times, killed him. Abramson argued the father had physically abused his son for years. The prosecution charged first-degree murder. Abramson got the jury to convict on voluntary manslaughter Salvatierra received probation. Not prison, probation. That result is the blueprint. The Menendez brothers didn't just hire a lawyer. They hired the one attorney in California who had already walked a child who killed a parent out of the courtroom. The question was whether she could do it again. With 2 adult defendants, 14 shotgun rounds, and a $1 million spending spree. Her strategy would hinge on a single legal doctrine, and that doctrine would hinge on something no jury can objectively measure. Most coverage of the Menendez case treats the defense as if it was about proving the brothers were abused. It wasn't. Not exactly. Abramson's strategy has a specific name in California criminal law. Imperfect self-defense. Standard self-defense is straightforward. You argue, I was in immediate danger. I responded with proportional force. Any reasonable person would have done the same. If the jury agrees, a full acquittal. No crime. But the Menendez case couldn't meet that standard. Nobody pointed a gun at them that night. There was no imminent physical threat in that den. Their parents were watching television. So Abramson went for the imperfect version. The difference is crucial. With imperfect self-defense, you don't have to prove the threat was real. You don't have to prove it was reasonable. You only have to prove one thing, that the defendant genuinely, honestly believed they were about to be killed, even if that belief was, by any objective standard, irrational. If the jury accepts that, it doesn't lead to acquittal. But it eliminates malice. And without malice, first-degree murder drops to voluntary manslaughter. In California in the 1990s, first-degree murder with special circumstances meant the death penalty. Voluntary manslaughter meant a maximum of 11 years, with parole eligibility far sooner, death penalty to freedom in under a decade. The only thing separating one outcome from the other, whether 12 jurors could believe that 2 wealthy young men from Beverly Hills genuinely thought, that Sunday night in August, that their parents were about to kill them. That was the gamble. And to win it, Abramson needed to do something no defense attorney had ever attempted at this scale: put the victims on trial. The first Menendez trial began on July 20th, 1993. One of the first major cases broadcast live on court TV. 2 defendants. 2 separate juries, one for each brother. 101 witnesses over 85 days. 405 exhibits. And Leslie Abramson turned every single day into a performance. Start with what the audience saw before anyone said a word. Lyle and Eric Menendez walked into court wearing pastel-colored cable-knit sweaters. Soft blues, pale yellows, gentle greens. They wore glasses they hadn't worn before. They looked like college freshmen showing up to family brunch. None of that was accidental. Lyle Menendez later told a friend named Norma Novelli, paraphrasing, "Buy me a yellow sweater. Have you ever seen a violent man wearing a yellow sweater?" That's courtroom psychology at work. Before the defense uttered a single legal argument, they had already set the visual frame. These are not killers. These are boys. The imperfect self-defense doctrine requires the jury to feel empathy, to see the defendants as victims. The sweaters, the glasses, the body language, all of it served the legal strategy. But the sweaters were window dressing. The real strategy was the testimony. Abramson and Lyle's attorney, Jill Lansing, called over 30 witnesses, relatives, neighbors, former teachers, tennis coaches. Every single one painted the same portrait of Jose Menendez, a success-obsessed tyrant who publicly humiliated his sons, who demanded perfection, who controlled every dimension of their lives. In legal terms, this was building the foundation for genuine belief. If the jury accepts that the brothers lived in constant fear for years, the claim that they believed their lives were in danger that night becomes harder to dismiss. Each witness wasn't telling a sad story. They were constructing the legal basis for imperfect self-defense. That was the foundation. The weapon was putting the brothers themselves on the stand. Lyle, Menendez testified for 4 days. He described a pattern of abuse by his father that had begun when both brothers were very young. Abuse that went far beyond verbal cruelty or physical discipline. He described conduct that, if true, would constitute serious criminal acts against children. The defense produced documentary evidence to corroborate parts of his account. When Lyle broke down on the stand, sobbing, unable to continue, the courtroom went silent. Journalist Robert Rand, who covered both trials, later said, "That first hour of Lyle Menendez's testimony was an absolutely pivotal moment. It just stunned the courtroom. Through the television cameras, you could only see Lyle. But in the courtroom, family members were crying. Jurors were visibly shaken. Reporters, hardened court reporters, were struggling to keep composure. Then came Eric. Eric was less articulate than his brother. Abramson struggled to draw the words out of him. But when she finally asked what he believed was the originating cause of the shooting, Eric paused.
What do you believe was the originating cause of you and your brother ultimately winding up shooting your parents?
Me telling.
You telling what?
Me telling Lyle that,
You telling Lyle what? Was it you telling Lyle about something that was happening?
my dad.
Okay.
My dad.
Your Honor, can I ask a leading question?
If you don't ask.
My dad.
Wait 1 second, Mr. Menendez. Okay, let me ask.
No, he was in the process of answering, so there's no need to ask him.
Can you answer the question?
Yes.
Okay, it was you telling Lyle what?
My dad had been molesting me.
And did you want something from your brother? Is that why you told him?
I wanted to stop.
Were you seeking help from your brother?
Yes.
And when you were in Israel in 1990, did you feel that seeking help from your brother was why your brother was in jail?
Yes.
Juror Hazel Thornton, who later wrote a book called Hung Jury, said, "I had to be thinking every second of every day, are they lying? Are they fabricating a defense? But the fact remains, I did believe them." The prosecution called it the abuse excuse. They argued the brothers had fabricated the entire narrative to avoid accountability for a cold-blooded, financially motivated double murder. Deputy D.A. Lester Kuriyama went further in his closing argument, suggesting that Eric's testimony wasn't credible and offering an alternative explanation for the brothers' behavior that had nothing to do with their father's actions. The women on the jury didn't buy it. And that's where things cracked open. This is where the Menendez trial stops being just a criminal case and becomes something else entirely. A case study in gender, perception, and what a society is willing to believe about male victims. Eric's jury, 6 women, 6 men, split perfectly along gender lines. The 6 women voted for voluntary manslaughter. They believed the abuse. They believed the brothers acted out of fear. The 6 men voted for first-degree murder. Lyle's jury split almost identically. Hazel Thornton later described the deliberations as a battle of the sexes. She said the men on the jury couldn't accept that a father could sexually abuse his teenage sons. Some of them remarked they wished their own fathers had shown up to their sporting events, completely missing the point. Others argued that nobody had witnessed the abuse firsthand. The women, according to Thornton, pointed out the obvious. The burden was not on the defense to prove abuse occurred. The burden was on the prosecution to prove murder in the first degree. But the men, she said, yelled at the women, called us names, and pounded on the table. Think about what that means for the legal strategy. Abramson's imperfect self-defense required jurors to accept that the brothers genuinely believed they were in danger. But half the jury couldn't even accept the premise that the abuse happened at all. Not because of evidence, but because of who was claiming to be the victim. The doctrine worked. The social barrier didn't break. After weeks of deadlock, both juries reported they could not reach a verdict. Judge Stanley Weisberg declared mistrials for both brothers. Abramson had not won, but she hadn't lost either. She had taken a case where two adult men walked into a room and executed their parents with shotguns, and she made half the jurors in each case say, "This was not murder." In legal terms, that's extraordinary, but she would never get the chance to do it again. The system made sure of that. The Los Angeles County District Attorney's Office was humiliated. They had lost the McMartin preschool molestation case. They had lost the first Menendez trial. And in 1995, they were about to lose the O.J. Simpson case. The Menendez retrial began on October 11th, 1995, and it was a completely different proceeding. Judge Weisberg, the same judge, made 3 decisions that gutted the defense. First, no cameras. The first trial had been a national event on court TV. The retrial was deliberately shielded from the media. No more public sympathy machine. Second, 1 jury instead of 2. Both brothers would be judged by the same 12 people. No more split dynamics. Third, and this was the one that killed the defense, Weisberg severely restricted the presentation of abuse evidence. The prosecution argued that the brothers' abuse testimony was uncorroborated. Only their own words, no physical evidence, no witnesses to the acts themselves. Weisberg agreed. The imperfect self-defense argument was functionally barred. Think about what that ruling actually does. Abramson's entire defense was built on proving the brothers genuinely believed they were in danger. To prove genuine belief, you need the abuse testimony. That's the evidence of where the belief came from. Remove the abuse evidence, and the legal mechanism collapses. You can't argue imperfect self-defense if the judge won't let you explain why the defendants were afraid. The heart of Abramson's strategy, the mechanism that had deadlocked both juries, was surgically removed. And there was more. Lyle Menendez did not testify at the second trial. After the first trial, a woman named Norma Novelli, who Lyle had spoken to extensively by phone, believing she was writing a sympathetic book, sold the recordings without his consent. The tapes contained inconsistencies, potential lies. If Lyle took the stand again, the prosecution would have torn him apart with his own recorded words. The new prosecutor, David Kahn, called the brothers' abuse claims, quote, "the silliest, most ridiculous story ever told in a courtroom." Then the controversy hit Abramson herself. During the retrial, it emerged that she had allegedly asked Eric's psychiatrist, Dr. William Vickery, to alter and delete portions of his therapy notes. Vickery testified that he removed content at Abramson's insistence. The DA's office investigated. The State Bar investigated. Both ultimately declined to prosecute. Insufficient evidence, but the damage was done. On March 21st, 1996, both brothers were found guilty of first-degree murder and conspiracy to commit murder, sentenced to life without the possibility of parole. The $14 million Menendez estate was gone, drained by legal fees, spending, and years of proceedings. The Beverly Hills mansion sold at auction for $1.3 million. Both brothers were declared indigent. Abramson, who had earned an estimated $650,000 for the first trial, was forced by the court to continue representing Eric at a reduced fee. She later told a reporter, "What I would really like to do is become completely invisible for the rest of my life." That could have been the end of the story. 2 brothers in prison forever, 1 attorney in self-imposed exile. But 30 years later, 2 pieces of evidence surfaced. For nearly 30 years, Eric and Lyle Menendez stayed in prison, separated, forgotten by most of the public. Then, in 2023, two pieces of new evidence surfaced. First, a letter Eric had written to his cousin Andy Cano in December 1988. 8 months before the murders, he wrote, "It's still happening, Andy, but it's worse for me now. Every night I stay up thinking he might come in. I need to put it out of my mind." That letter was never presented at trial. The defense didn't know it existed. And notice what it does legally? It's independent evidence of genuine belief. Written months before the crime. Not testimony coached by a defense attorney. If that letter had been presented in 1993, it would have been exactly the kind of corroboration Weisberg said was missing. Second, a sworn declaration from Roy Rossello, a former member of the Latin boy band Menudo. Rossello claimed that Jose Menendez, who was an RCA Records executive when Menudo was signed to the label, had drugged and raped him in the 1980s, when Rossello was a teenager. If true, Jose Menendez was not just an abuser within his family, he was a predator with other victims. That's corroboration from outside the family. Exactly what the second trial judge demanded and didn't get. In October 2024, pushed by a Netflix documentary and a Ryan Murphy drama series, then Dia George Gascon recommended resentencing. In May 2025, a judge agreed. Eric and Lyle were resentenced to 50 years to life, making them immediately eligible for parole under California's youth offender laws. Both brothers appeared virtually from prison. Both took full responsibility. Eric said, "I committed an atrocious act. My actions were criminal, selfish, and cowardly. No excuse, no justification." In August 2025, both appeared before the California Parole Board for the first time. After nearly 10 hours of hearings each, both were denied. The board cited a moderate risk to public safety, prison violations, including illegal cell phones, and what one commissioner called Lyle's poor threat perception. They can reapply in 2028. So, the question: did Leslie Abramson's strategy fail, or was she 30 years too early? In 1993, she asked a jury to believe that two men could be sexually abused by their father. The men on that jury couldn't accept it. In 2024, when the same story reached a new generation through Netflix, millions accepted it without hesitation. The legal doctrine of imperfect self-defense has expanded since the Menendez trials, partly because of the Menendez trials. The understanding of male sexual abuse has shifted. The stigma hasn't disappeared, but it's cracked. Abramson saw something in 1993 that the legal system wasn't ready to see. She built a defense around trauma before trauma-informed justice was a phrase anyone used. She understood that the case was never about whether the brothers pulled the trigger. It was about why. And the answer to why depended entirely on what a society was willing to believe. That's reasonable doubt. That's this channel. I'll see you next week.